I think it's important to remember throughout this debate that this bill is unashamedly about reducing the number of victims and public safety in general. Since the election, Mr. Chairman, 4 more people have died at the hands of persons who, had this law been in place at the time they committed their crime, would have been in jail. So that is not rhetoric, it's not spin, it's a simple fact. I heard someone insultingly say the other day when this subject came up in another forum, oh, you can't say that about the numbers we talked about in the initial phase because some of them might have died of diseases. As the Americans say, Mr. Chairman, parleys. I've been involved in debates recently with a number of people on both sides. In fact, Mr. Lees Galloway and I debated each other a week ago. A very civil affair it was too. But the most interesting one was probably a debate in Auckland a couple or 3 weeks ago with Professor Warren Brookbanks, a respected academic at the University of Auckland, and a Dr. Eakins, who has been publicised or published quite widely on this subject. Now, Dr. Brookbanks was good enough to agree several things in that debate, Mr. Chairman. First, he readily agreed that only in the tiny pool that is New Zealand are all academics opposed to this legislation, or most academics. And Professor Brookbanks acknowledged that in the United States, opinion is about even on whether the 3 strikes laws in the 26 US states that have them have been effective. But he went further. Professor Brookbanks also agreed with me that the 2 phenomena I pointed out to him was in fact evidence of deterrence. One of them is that of the prison population in California who are strikers, about 60% of them are first strikers, about 30% of them are second strikers, and only about 10% are third strikers. And Professor Brookbanks agreed with me that that distribution indicated that while first strikers were more numerous, a much smaller number wished to go back for another go, and a very much smaller number wished to go back for a third go. Secondly, Professor Brookbanks agreed that the fact that prior to 1994 there was a net inflow of parolees into the state of California. 1994, of course, was the year the law was enacted. Prior to 1994, parolees came from other states to California, I presume because of the weather, nice place to live, lifestyle, etc. Post-1994, there is a net outflow of parolees, particularly among strike offenders who get out after a second strike and quickly cross the border to Arizona or Washington State, which don't have strike laws. Professor Brookbanks agreed with me that that was evidence of deterrence. Now, another thing that impresses me, Mr. Chairman, is my ongoing communication with a lobby group that I have referred to in the House before called FACTS, Families to Amend California 3 Strikes. And note that their name includes, or the name of their organisation is Amend, not Abolish. And I sent them the original Act version of this bill, which was, of course, quite different from what we're debating today. And I have the comment on record, Mr. Chairman, David, compared with what we've got here, yours is wonderful. And I actually spoke to the president of FACTS a week or so ago, a lady called Jerry Silver, and told her where things were at and what was happening. And she again expressed great surprise that, as she put it, we don't have LWAP, as they call it, life without parole, in her words, even for the really bad guys. And I recall when we visited FACTS 3 years ago, together with Ty Hobson, the widower of Mary Hobson, one of William Bell's victims, Jerry couldn't believe that, as she put it, this guy was on the street, referring to Bell, with 102 previous convictions. So I think it's quite instructive that a left-wing lobby group seeks only to amend the law, and they'd be delighted with what we're going to pass here. They'd be delighted with it. They don't seek, Mr. Chairman. Chairman?
David Garrett.
They don't seek to abolish the law, Mr Chairman, because they can see that it's working. Now, another thing that's interesting that's never been canvassed in the House before, to my knowledge, is that in 2004, the Americans have a system which we would call binding referenda, and they're called propositions. And in fact, the original three strikes law came into being in California through a proposition. But in 2004, there was an attempt to weaken their act to something pretty close to what we've got. Most notably to narrow the focus down to violent, what they call serious violent felonies. Because, as I've said in other speeches, the undoubted injustices in California have arisen from this grey category called technical felony. And that is what has led to the cases that are much discussed of people going to jail for life for stealing golf clubs, etc. Now, a proposition was put on the ballot in 2004 to weaken California's quite wide or very wide law down to something very similar to what we have, and it was defeated, Mr Chairman. But it was defeated most heavily in poor black counties. Rich Liberals from San Francisco, they wanted it weakened because crime doesn't affect them. But poor black counties in Los Angeles, they rejected it by a country mile. And I was reminded of that fact that poor communities are those most affected when I visited the Maori wardens a few weeks back. And I didn't have to finish what I was saying about crime affecting poor people worse. They knew it. And I was a bit nervous presenting the three strikes argument to these people, but they were right on board with it. They thought it was a great idea. So, Mr Speaker, it is indeed a victim-focused bill. It will, at the very least, reduce the number of victims through incapacitation. It cannot do otherwise. Sadly, aside from tragedies such as what happened to the corrections officer over the weekend. But those people are doing that very challenging job on behalf of the rest of us. And Mr Speaker, Mr Chairman, I cannot see any good reason why the deterrent effect that Professor Brookbanks acknowledges from the data overseas would not be replicated here. And we know that the adverse effects, the going to jail for stealing a pizza or going to jail for stealing golf clubs, simply cannot happen. And I'm actually disappointed that some in the opposition, and I don't mean the parliamentary opposition, but some of those out in the community are being frankly dishonest and still saying that under the law we're going to pass, people can go to jail for life for stealing a chocolate bar, when they must know, if they've read it, that that is simply untrue. Mr Chairman, of course we're supporting the bill. It was our idea in the first place. We believe very firmly and honestly that it will make a major change, but can I just close in saying that of course we need to look at the causes of crime. I'll take a later call, give someone else a chance, but we do need to look at drug treatment. I had a very interesting lecture this morning from an American judge about drug courts in California and what they have done. But we have to start somewhere, and we're starting by doing a change of direction and saying to violent offenders, if you cannot learn from being told twice by a judge and serving by definition a lengthy period of imprisonment when you add first and second strikes together, then you have no place in the community. And we make no bones about that, and we're unashamed of it. Thank you.
Honourable Clayton Cosgrove, just